Hello guys, and welcome to another segment entirely of my lecture where I will be discussing about directors as a board, the types of directors that we have. That's the de jure director, the de facto director, the shadow director, the non-executive directors, and then the executive director. So sit back and enjoy the next scintillating series of lectures. But today we'll be talking about the meaning of directors. I know that in my former videos I've explained the meaning of directors, yes, but this particular episode is dedicated to defining directors in accordance with the Companies and Allied Matters Act, taking into consideration every relevant provisions. So let's begin. Now, when we are to define directors, although we are supposed to go to the definition section first, but there is a very important provision in our CAMA that gives us an insight as to who a director is, and that is section 269 sub 1 of CAMA. It tells us that a director of a company registered under this act is a person duly appointed by the company to direct and manage the business of the company. This function of directors was first noted in section 87 sub 3 of CAMA, which states that unless otherwise provided in the articles, company's business is to be managed by the board of directors, who are to execute all such powers of the company not already required by the act or by the articles to be exercised by members in general meeting. I'd already explained this when I was talking about the power holding of the company, so I don't think that at this point this should come as a surprise. When we are talking about directors, basically when we are looking at the definition of section 269, it tells us that a director is duly appointed to direct and manage. That is the most important thing when you're talking about who a director is. He directs and manages the company. In another class entirely, I defined to you what the business of the company is, what will it entail. Well, I was trying to give the Canadian position, the Australian position, vis-a-vis the position in CAMA. So that should not as well come as a surprise to you to determine what exactly the business of a company is. So with that, we move to what was stated by JSL MR in Ray Forest of Dean Coal Mining Company, where JSL MR noted that the position of director is that they are really commercial men managing trading concern for benefit of themselves as well as the shareholders. You need to know, if you followed by series of cases, especially in Leonard's case, in Meridian's case and others, where the court stated, when it was talking about liability of certain people, the court stated that it is not every time that all shareholders can sit down and be passing resolution as to the affairs of the company or as to the business of the company. They have to delegate these particular duties to certain people. So according to our CAMA, these people who are supposed to manage the affairs of this company, who are supposed to direct the affairs of this company, are the directors. Do you understand? According to JCLMR, he is saying that they are commercial men who are concerned with the trading of the company. That is, in our own language of CAMA, with the business of the company. Do you understand? Then we move further to section 868 of our CAMA. What does section 868 of our CAMA say as regards defining to us who a director is? Now, one thing you should note, as you can see from my notes, is that there are two legs of that particular definition. The first leg is that it tells us that a director includes any person occupying the position of director by whatever name called. Whatever the company decides to call him, by whatever name called, means so far he is directing the business. So far he is managing the business of the company, he is a director. If you like, call him gateman. If you like, call him cleaner. If you like, call him director itself. If you like, call him general overseer. The question which we should ask as to determine who he is should be, does he direct, does he manage the business of the company? Do you understand? That's why it says occupying the position of director by whatever name called. Do you understand? Now the second leg tells us that a director includes any person in accordance with whom directions or instructions the directors of a company are accustomed to act. These are the people known as shadow directors, but we are still going to talk about that. People who you don't see, but the directors that you see, they are accustomed to act by the direction of those people. So we have two different people here. We have the real directors that everybody know, the overt one. Then we now have the covert one, the one that is hidden, the one we don't see. Do you understand? So when you are talking about those kinds of directors, we are saying that those directors, when they give orders that the ones that we can see are accustomed to act on, those people, by virtue of those orders that they've given, might not be the directors that we can see, but they are called directors in shadow. Shadow meaning they are under the shadow of the ones we can see. We cannot see these particular ones, but they are also directors. Do you understand? So this definition has no reference to modalities of appointment. That is the first thing you need to know about the definition. It has no modalities of appointment. It includes those who are duly appointed and those who may not have been duly appointed, but acting and participating as directors in decision making. So you see, while we are going to the different kinds of directors that we have, you will see that there are three kinds: the de jure director, the de facto director, and then the shadow director. You will see that there are certain people who are not duly elected, but then they are acting for the company. Do you understand? They weren't elected or appointed, but they are acting for the company. You will see that in my note I said, such person occupy the position of a director and therefore qualifies as one under the first leg of section 868. Then the question that I posed, how then do we relate section 269 of CAMA with section 868 of CAMA? There is no equivalent as section 269 in the former act, that is in the 1968 act. What does that mean? You see, the part that tells us that a person that has been duly appointed to manage and direct would be defined as the director of a company was not in the 1968 act. What you can find in the 1968 act is section 868, the equivalent of that gives us the two legs. Do you understand? But this new one now tells us something brand new about what a director is. Do you understand? It gives us a perspective, but you need to know that that perspective is only in line with the jure directors. Do you understand? It tells us who a director in fact is supposed to be, someone who has been duly appointed. It doesn't tell us about other directors, and we will see the reasons why we are interrogating those directors. So, like you can see in my note, the first leg of section 868 covers both de facto and de jure. So with everything that we have said so far, it is obvious that while interrogating section 269 sub 1, while interrogating section 868, we can see three types of directors. We can see the de jure and the de facto director from the first leg of section 868, and in the second leg of section 868 we can see the shadow director. Therefore, three types of directors. How do they interplay in CAMA vis-a-vis real life? What are the extent of their powers? And very importantly, what are the extent of their liability? Would the company be liable to a de facto or a shadow director? Those are the questions that we will be answering in our next series of classes. See you in my next class.